All right, Marshall.
Hey, Greg.
Week in immigration news. Nothing happened last week, so we have to kind of scramble to come up with some ideas for things to talk about. Is that right? Or
Yeah, nothing happened today either, so
yeah,
let's wrap it up.
unfortunately, that will not be the case. And it was just a matter of figuring out what the order is for the week's nonsense,
Mm.
which there was plenty of. But well, in terms of the most ridiculous story of the week, and there are many, but the most ridiculous one is the stupid gold card.
Yeah.
That they just don't want to let go on that, and it sort of morphed into something that was completely illegal to now something that is very illegal, but people are like at least have to think about it for a second before they can say that it's completely undoable. So basically, what we have with this gold card, which I'm guessing, and we'll probably see in a second in the comments that we'll hear from people like trying to say, I wonder if I qualify. So they actually produce some very official looking forms. Let me see if I can do a screen share for a second and kind of show what this form looks like.
Are you looking for the 140G?
Yeah, hang on. So I got to do, I don't do this very often here. Can you all see this form? Marshall, do you see it?
Yeah.
All right. So this is the very, very official USCIS form I-140G. G is for gold. And it basically, the way this program works is you have to be applying for an EB1 A, extraordinary ability, or an EB2 national interest waiver. And basically, if you donate $1 million to the Treasury of the United States, it's hard for me to get through this without chuckling. Then you are considered to have either extraordinary ability or meet the national interest criteria. And my first suggestion would be if you're applying for this category, and I'll tell you why you'd be an idiot to apply for this category in a second. But if you're applying for this category, is there any world in which you would not pick number one versus number two? As far as like picking EB1A over EB2, like why would you ever pick EB2? And basically the idea I think on EB1A is that it's sort of like a one-time thing, like an Academy Award or an Olympic gold medal, and you don't have to meet any of the other criteria. I think is the way this is the way they intend this to work. I'll show the instructions as well in a second, but the and then the second thing you could do is you could be a company filing on behalf of an individual, and if you are a company, then you have to pay $2 million for the one person and $1 million per person for any accompanying spouse or children listed in the petition. So why would you ever do that if you're a company versus like just giving your employee $1 million and have them can be contractually obligated to pay it to the Treasury so that it would cover spouses and kids and you'd only be paying half the money? I mean, there's some like I don't understand. I'm just trying to understand sort of what the logic is on this. There's not a lot of other information here, just the usual like biographic information.
Source of funds, information too.
I mean, information news requesting. I say the country. Where's the you got some employment history here, education history, marital history. Oh, source of funds. Yeah. So I guess you're trying. You have to show here that you like. It's not organized. You're not an organized crime guy. Although you can be an organized crime guy and still curry favor with the administration, or be into like crypto fraud and that kind of stuff. That doesn't seem like that stops things. But my guess is, if you made a significant donation to the Trump administration and you have criminal issues in your background, you probably could still get away with it here. Just I thought, but so they have they're asking you some information on where the money comes from. And then the, oh, here you go.
Admissibility issues.
Yeah. Engaged in or sought. Yeah. Have you like has your gold card money come from terrorist activities? Well, I'm glad they at least asked that question on there. But you know, most of the rest of his stuff is you know, okay. You know, back on this. Let me unshare that for a minute. Now there are some instructions as well. So let me get the instructions out. And kind of show people that share screen, and we have instructions. All right, so here we are on the instructions. What I'm trying to figure out is sort of like if they give you how much information they actually give you about EB1, like answering your questions on how to like how does it work with EB1. For an individual filing an I-140G who makes this gift, it just says you get a gold card, and it doesn't seem to say that you have to meet any of the other requirements that would normally be applicable for extraordinary ability or national interest waiver. Would you agree that that's kind of like the way you read it? Because
Yeah.
I didn't see anything that said you had to otherwise meet the requirements for that category, like demonstrating that you meet 3 of the 8 categories or that you meet the Kazarian standards or any of that stuff. It sounds like they're saying basically fill out this form. Do you even have to fill out a regular I-140 form anymore for EB1A, or is it just this?
For the gold card application, it would just be the I-140G.
Yeah, so you don't even fill out the I-140, which, you know, they're basically saying this is a new EB1A category and a new EB2 national interest category, and they run on their own track, and you don't have to meet any of the other requirements. Now, let me just sort of preface this with a couple of things. This is illegal. This is not going to, and basically the idea that people can cut in front of a line by just paying money and not actually, well, I don't know if they cut in front of a line. I guess they're still in the regular EB1 and EB2 categories here, but they essentially are pushing a lot of people further back in the line that are going to be applying later. That is going to result in litigation. The question is how fast that's going to happen. And that is going to be, and here's a tip. Whoever sues on this will win. So if you're a lawyer out there and you want to, you want to get into federal litigation. I mean, I don't want to tell people to like just file a bad lawsuit. And if Chuck Cook or any of my impact friends are watching this, they're probably cringing. However, I will say this is a layup of a federal lawsuit because Congress has to create a new visa category. You can try and call it EB1A. You can try and call it EB2 national interest waiver and kind of couch it under those. These are new visa categories. Visas are statutory. They are created by acts of Congress. Congress did not pass legislation creating a gold card. Congress could have passed legislation creating a gold card because they had passed they've already passed a couple of immigration bills this year. They passed this big, beautiful act that had lots of immigration provisions. They passed a $900 billion defense bill today on there. Congress knows how to pass legislation if it wants, and Trump has been able to get certain bills passed when he wants them. He doesn't even try it on this one because I think he knows that the votes would just not be there for this green card category. I think a lot of people would basically, a lot of his Republicans colleagues would not be voting for this if they had the opportunity. There's just not the votes to pass it in Congress. So what is going to happen? You're going to pay $1 million. You're going to pay $2 million into the U.S. Treasury, and then your case is not going to get adjudicated. And then you're going to have to go and basically probably go to court and ask for your donation to the U.S. government to be returned on there. So any clients who call me and ask about this, I'm going to tell them this is a scam. This is not a real category. This is not authorized by Congress, and these applications are going to be accepted very briefly, and then there's going to be an injunction holding, telling the government you can't take any more of these, and then eventually this whole category is going to be ruled illegal, and then it's just going to be trying to unwind how people get their money back. So my suggestion is do not participate in this. I have yet to see any explanation from the White House on why this is legal. Have you seen anything where they've even tried to give an explanation of why it's authorized and legal? I haven't even seen that. All I've seen is announcements. And this does show you how these are professional people at USCIS who work on these forms and who work on designing these programs and all that. And, honestly, they should have resigned before they worked on this. If these are professional people at USCIS who are, consider themselves nonpartisan on there, and you're asked to do something that is blatantly illegal like this, you need to resign. You can complain. It's probably not going to do anything for you, but that's this is just an embarrassment. And I'm usually when there's this kind of stuff, I guess the debate is, it's like, should I put this in the visa.ai law library? This stuff. I might, but it's not. I might also put. I'm going to have to find it very quickly. I'll probably get Dan Kowalski, who wrote an op-ed, an opinion on this Substack today about this. And Marshall, I was sending you some excerpts of that earlier. Dan is a contributor to the library for the AI, and I'm definitely putting his opinion piece in, and hopefully, if anybody asks, tell me about the program, the gold card program. Hopefully, his op-ed will come up if there's any links to anything like that, so people really understand what a criminal enterprise this is, basically, on the part of the administration. Okay. Anything else we want to say about gold cards, Marshall?
No, I think we covered it, but maybe next year we'll talk about a special student visa for Trump University or something equally.
Probably. Oh, I made a banner, but it's not a very exciting banner for that one, but it'll be it's gone. All right. Let's talk about the H-1B, H-4 enhanced security policy that's effective on December 15th. So what's that about?
Right. I think you and Elisa touched upon this a little bit last week when it was announced. Since the announcement, we've seen a lot of chaos unfold as it's kind of getting closer to the launch date on December 15th. We've heard lots of reports, and there's tons of articles being published this week about individuals who've had their visa application appointments canceled abroad.
Right.
So we've heard of, dozens. I started to calculate how many people have been affected so far, but predominantly in India posts, there's been a huge swath of applications that have been canceled for December 15th onward and been rescheduled 3 months down the road, even upwards of 6 months. So there are tons of people who are already abroad getting ready for their interview that have, planned this trip for a year or, more. So it's a real gut punch for people in that situation. They're stranded.
Yeah. I hate to tell people this every week, but there's usually, unless there's something that requires you to travel from an immigration perspective, like you have to have a new visa in order to be able to re-enter the U.S. and you have no choice in the matter. Any travel is really, I think, risky. The only ones I think are not travel. I would say maybe not a big deal if you're from Europe and have a visa that has several years left on it, and you're probably okay in those circumstances, except at some point Trump could just announce an across the board, every category travel ban. with barring anybody from coming into the United States on any kind of visa. And you may say, well, that sounds a little crazy, but you might remember he actually did that during COVID, where he basically barred all entries into the United States at one point. And maybe there were some more legit reasons for that, like public health, but he doesn't seem to be too worried about appearances on there, and he's largely, it seems like he's moving in that direction at some point of having a much broader travel ban. Okay, although he went on this rant, he's been ever since the people started telling him that prices were going up, he's getting a little nervous, and he started going out and doing events where he's supposed to talk about affordability, and then he kind of drifts off into the usual rants and things like that. But he went on some rant yesterday about why can't we just let in people from Norway and the white countries? Why do we have to let in all these people from all these other countries? And it's like, Donald Trump, that is very, that is you being you on there. And that is when a lawyer goes to court and they like to say that you can sue and you say that a policy is based on animus and not on actual legitimate public policy, they find your Truth Social posts, they find your quotes from your rallies and all that, and the judge looks at it and it's like, there is nothing. This was not a rational policy. This is rationales that were designed to basically cover up the real ideas here. So anyway, so that's that. I did actually. Well, I'm gonna interject on the agenda, and since I'm getting good at screen sharing tonight, I'm going to show another one. We are onboarding a case for impact litigation, a new case on UNT litigation. So we just started. We just got pushed out the AI apps that help us with the onboarding of plaintiffs. That's all done. But if you go on to impactlitigation.com, impact is IMM, get it? Impact like immigration. PACT litigation.com. You can see the onboarding cases. So if you are somebody that is, if you're either a lawyer who represents UNT non-immigrants, or you're somebody in U or T status, we're looking to sue to get a judge to affirm that the deferred action available to UNT prevents ICE from detaining people. And so that's been a big problem recently with ICE basically taking the position that they can detain those people already granted deferred action based on a bona fide determination of their pending U or T non-immigrant status. So that's what this case is about. And there's an FAQ and all kinds of information here. So that is a quick commercial for that lawsuit that we are just starting onboarding this afternoon. So if you're in that category or you're a lawyer and you represent people in that category, you should probably take a look at that. Okay, Marshall, we are moving on to the, here we go. Hold on, gotta put the banner up. Where'd it go? Oh, here it is. So that's my description. This latest news. So how is CBP proposing to end tourism to America?
Well, they're making what had been one of the easiest, convenient ways to travel to the U.S., the ESTA program, a lot more challenging to use and enhanced security requirements.
So let's remind people what ESTA is, because, well, I mean, a lot of people know about it, but basically ESTA is visa-free travel for 40 people from 42 countries that are considered to have a very low overstay rates in the United States, that are considered to be pretty safe tourists to have here, as far as complying with immigration law, not working illegally, all the other things that it takes to get into the ESTA program. And now we are basically telling all the people that are coming in from these countries that they have to go through all kinds of new screening. So, like, what are some of the new ways?
Right. First, they're going to decommission the website, which is the convenient way that everyone creates the application now. Maybe it'll just help to kind of explain how simple it is to use now. Right now, if you want to apply for ESTA, you, I think, pay $40 online. You fill out an application, has some pretty basic biographic information about yourself, emergency contact, and your trip, and then you're approved for 2 years. The new rule proposes that they're going to decommission the website and have all the applications go through a mobile app. So it has to be completed on, I guess, a smartphone or something.
Okay.
So they can incorporate a biometric component to the application, which would be like a selfie or something, I think.
Okay.
I don't know if they could scan your thumb on your phone too, but just an enhanced biometric component.
Yeah.
And then what's got a lot of, yeah.
They want a lot of nosy information about your social media and your email,
Exactly.
your addresses and your phone numbers and all that kind of stuff.
Yeah, so it's 5 years of social media history is kind of what made the headlines today. So
That's
yeah.
great. All right, and we have and they want this. Is this for just for adults, or is this for also for like teenagers and kids?
Not sure. Maybe it would be applied universally. Plenty of kids have social media accounts now, but
Right. I mean, I know they want information on names, addresses, birth dates, birthplaces of kids, but I don't think it's really clear about like whether they, in their own right, have to provide all that information. And the headline was like not, that I just said was like the proposal on tourism to America. It's like people are already pretty. I mean, I've been on the flights back, and from Europe. I've been on several flights to Europe since Trump came in, and it's like it's mostly Americans that are on the airplanes that are coming back from Europe. It's not Europeans coming to the United States. And that's a big chunk of the 42 countries or the European countries. But it's the tourism to the U.S. is already taking a big hit over the last year. I mean, I was just in the Latin American chapter conference for AILA at a meeting in the Caribbean, and all of the there was a lot of jumbo jets from Canada. From where was this? It was in Barbados. It wasn't even like a big island on there, but there were jumbo jets from Canada, from KLM, from British Airways, and all that. And the Caribbean is like booming for tourism right now from people that would normally be like heading to Florida. I can't imagine that, the governor of Florida is going to go out and basically endorse this concept. This has got to be, he has to be hearing on a daily basis about how much of a hit that they're taking. But anyway, you can file a comment if you would like. I recommend that. The comment period is you have 60 days to make a comment. If you are in a world that depends on ESTA, I would consider making a comment. Hopefully, enough of those will come in, and maybe it will be slowed down if that happens. But we've been surprised before. You never know on there. Trump, is a guy who is he's a hospitality guy. He, to some extent, his career has been built on getting foreign tourists to come into his hotels and to his resorts. So, maybe he'll get it, but that's where we are. All right, moving along. What's the next thing? We have prudential visa revocations. So
yeah.
So tell us what this is. This will sound familiar, but Marshall, I can describe it, or you want to?
you were more involved with the student revocation lawsuits going back.
Yeah. So people may remember the students that there were about 6,000 students that had their visas revoked, their 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 CVIS records revoked by ICE, and were basically put in this limbo. And what was going on then was the State Department apparently was going through a database and basically just matching names for students that happen to be in this database. But they weren't paying very much attention to the actual details. It was like, if you're in there, we're going to assume you're a criminal and we are revoking your visa and we're pulling it. And as it turns out, there were a lot of people who had been arrested, but on but it was determined that it was completely incorrect and they shouldn't have been, and they were released, but they're still in that database, even though in America we believe in this thing called innocent until proven guilty. In this case, they were sort of like, they weren't released on necessarily on technicalities. They were released when they figured out that like this person is not guilty of anything, and there's no crime here to prosecute. They also put a lot of people in who reported crimes, that they were just reporting a robbery, or they were reporting being a crime victim of one sort or another, and then they found their visas revoked because they were in this database, and State Department wasn't even checking to see like why they were in the database. They just said, you're in the database. It doesn't matter whether you're a victim or an actual perpetrator of a crime. So we had a lawsuit at Impact that and there's actually been some recent news on this, but we had about 440 students, I think, for a case that we filed in Atlanta because that was the original group of plaintiffs was for Georgia students. And the DHS settled with us, and basically, as that case, they gave us everything we asked for, including like reinstating their CVIS status and guaranteeing not to ever punish them for any of this stuff. I mean, we had this list of like 10 demands, and they gave us all of them. But one of the most important ones we gave is that they said, well, DHS said we'll settle. State Department wasn't ready to do that yet, and we just said to the judge, we want, and we agreed with the administration gave in to us as well. They allowed us to dismiss the case after we got the settlement with DHS and got all the students taken care of. Then but they agreed to dismiss it without prejudice so that we could refile the case against the State Department for visa revocations. We're filing for, I don't know how many we're filing for at this point, but we're filing for a large chunk of those students, again, the same students, in a new case against the State Department. And it's a Boston, it's going to be a Boston case. So that's about to happen. The reason I'm going through all that history is the State Department, rather than basically seeing the writing on the wall and very likely going to lose, they're now announcing, now we're going to extend this out to a bunch of other non-immigrant categories. And there were H-1Bs, J-1s in there, but basically we're going to start seeing these visa revocations happening again for people in these other categories. So be on the lookout. Definitely be careful about, if you have had you think you might be in any of these databases, you need to be really careful about travel, because it may not be communicated that your visa has been revoked before you leave the country. And you may think, I've got a valid visa, I can totally come back in. And then you're going to find out once you're out that the visa was revoked while you were out under this policy, and you're not going to be allowed in. It's going to be a lot easier for you to fight this policy from within the United States. So My guess is there will be new litigation against the State Department for people in this situation. The reason why the State Department, incidentally, why you can win these cases against the State Department is there is this concept called consular non-reviewability, but it requires an individual determination by an individual officer. The State Department can send from Washington information to the consulate that would allow an individual officer to then go in and look at the record and make an individual determination. They cannot make send a blanket list to all the consulates around the world and say revoke these visas, or even what they did, which was they revoked them like from the top. They never let individual officers have the review, and that's what consular non-reviewability says, that the courts are not going to second guess individual officers who have looked at all the facts and made a determination. But when it's happening as a matter of policy and it's being directed from DC, not the consular officers, that's a problem. And that, I think, is why this policy is probably going to suffer the same fate that the students are. So that's that. I guess the lesson of that is, again, don't travel unless you need to. You don't need a valid visa to be, if you're in the United States with a valid I-94. So you can be in the United States with an expired or revoked visa. But what I would anticipate is that if they revoke the visas, then they may try to revoke the I-94 and the status in the United States. But that's going to be easier to defend if you're already here and you can just go to court and ask a judge to block whatever is happening. So if I were trying to advise people who might potentially be affected by this, I would tell them don't travel and be prepared to fight it from within the United States. Any difference in opinion on that, or is that?
No, I would just stress the travel part. I've seen issues with someone that's had a prior criminal issue that's already been in front of the consulate before be the reason for a potential revocation. So it does appear pretty unpredictable, and yeah.
Okay. We had a last topic, and then we can see if people have questions they want to ask, and we can and then we can talk about that. So moving back to the my wonderful banners for the week. So USCIS has opened up what I guess we would call a Black Ops Center. This is their, I'll tell you sort of like what I'll show you again, kind of like, since I have mastered screen sharing for this. But this is their big announcement. They've established this new center to strengthen immigration screening and target bad actors. So who knows what they're doing in this place? But it's it's lots of top secret stuff. It's lots of surveillance, and it is now the place that is basically. My guess is they're going to be doing a lot of stuff the State Department was doing, which is like combing social media, doing surveillance to the extent they can. But that's that's this new thing on here, and it's a new a new office of USCIS. So we'll see over time what this actually means. But that's the last thing that we had as far as news. I'm sure we could have come up with other things, but there's always like horrible news about citizens being arrested, or the front page of the New York Times today had a story on just horrible conditions, health conditions for people that are being detained at ICE detention centers, including people with like cancer not getting access to treatment, people, like all kinds of horrible stories. So there's a lot of that. I think you'll pick up a lot of that just like through the general news media. And we'll be talking, we'll obviously talk more and more about that. But that is that's the mostly I think we hit a lot of the issues last week with the asylum ban and all that. And there's really sort of like not a lot of new developments on those stories since last week, but we will keep people up to date. So we had a couple of comments. So we had Zach Shum, who's one of our regular viewers, saying, "Yeah, they're talking about this gold card that the where were the provisions in there for a refund? They, and there seemed like did they? I don't think they actually released a form or instructions on how one actually makes that payment to the U.S. Treasury. But I think it's pretty much just like sending a check to the pay your taxes. You like just write a check to the U.S. Treasury, you mail it to the Treasury, and then I guess you show that. I don't know. You take a screenshot. You take a picture of the check and show that it cleared your bank account. I mean, there's like I haven't seen any of the information on sort of how one actually does it, but I would not want to be getting a refund listed as a donation. So that is a good reason. That is a good thing to be concerned about. Another thing, why would anybody file these when they can just file EB-5 and have the money invested instead? That's a good question. I would say the EB-5 is at least a legitimate, real program that Congress has created, and the rules for that program have withstood litigation already, and the fact on one of the stories that we had, but we didn't talk about it at the time, but our friend Matt Galati in Philly, who's a great EB-5 lawyer, had victories recently on the court victory on the EB-5 filing fees, and they had to drop the fee by several $1,000s because of his litigation. But it exists. Those programs exist, and the investments themselves are usually in very 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 real projects like Ritz-Carlton hotels and those kinds of things around the country, and the program's been around for 35 years. They just raised the investment amounts recently, but it's still, for a lot of people, it's still in the realm of possible as far as coming up with that kind of money. And the EB-5 has its own quota. Now EB-5 might be, if you're Chinese, I don't know where the EB-5 backlogs are, but there's definitely a large backlog for China, and there might be a backlog in EB-5 for India, which might be a reason why you wouldn't want to file for it. But I'm not sure it would be any longer than EB-1. Marshall, I don't know if you have the visa bulletin handy, but
yeah, it looks like, it's broken down into multiple categories, so it might depend on where you fall in it, but
yeah, I'm looking right now at the December visa bulletin for EB-5 final action dates. So it's 2021, July 2021 for India, and July 15, 2016 for China. So it's a little bit further back. It's about a March 22nd, March 15, 2022 is the EB-1 backlog for India. So this is about 9 months behind what it is for there. And for EB-5 for China, it's actually backlogged only to January 2023 for EB-1 versus July 2016 for China. So in the case of China, Sahil, there would be a really good reason to file in this category, an EB-1, a real EB-1. Don't file an EB-1 in this category. But if you actually were looking for a faster strategy and you can file an EB-1 and you were from China, you would be saving many years. If you're from India and you're trying to decide between EB-1 and EB-5, EB-1 is slightly faster, like 9 months right now, and who knows if it'll stay at the same pace than India. But that's that's not that big of a difference if you ask me. So good question. Will we be joining litigation on current pauses and delays? So That is a good question. There are have been so many different policies that have been announced in the last couple of weeks, and there are a lot of lawsuits that I've heard being discussed. Right now, we are really all in on the H-1B $100,000 lawsuit, and I'm sure people want to know what's going on in that case. And Marshall and I were talking about beforehand, like what I could say and what I could not say about that case. But what I will tell you is that, just to describe again on that, because I know a lot of people that watch this, that H-1B $100,000 fee is a huge concern. There are two lawsuits that have been filed on this subject, one on the East Coast, one on the West Coast. The East Coast suit in D.C. was filed by the U.S. Chamber of Commerce and the American Association of Universities. That case was filed after another case that I'm actually co-counsel on called Global Nurse Force. And that case, the Global Nurse Force case, was filed in San Francisco. The cases have a lot of similar legal theories. They're not precisely the same, but there's some similarities. And that case, the Chamber case, while it was filed a couple weeks after ours, is actually further along in terms of next steps than ours, including their preliminary injunction filing having already been done. One of the reasons why it's a little easier for the Chamber and for the case is they are not seeking to protect anybody but their own members and the members of the American Association of Universities. Now, granted, that covers a lot, but the Chamber, if you want to join the Chamber of Commerce, you're probably going to pay about I don't know what it is, probably about 80 grand. I think it's the figure that I've heard. I'm super happy that the Chamber is suing. I'm very happy that they're going to benefit thousands and thousands of workers and all these companies that are Chamber members. But it is not going to extend, when they get their injunction, it's not going to extend out to everybody. The bulk of employers that file H-1B applications are not likely Chamber members, because it's a lot of small companies that file H-1Bs, as well as big companies. But certainly the universities are a large number of the filers. So that will help a lot. And I'm rooting for the Chamber. Trust me, they're winning that case is really important. But the case that we're working on the West Coast, the Global Nurse Force case, our stated aim is to basically make sure that everybody benefits when we get our relief. That will, I'm not going to discuss sort of like at this point, I'm under strict orders there's like 25 lawyers that are working on this case, and we're all under orders not to talk about specific strategy and give it away. And you may say, why not? Well, the Department of Justice doesn't need to have Greg Siskind saying on his live stream what day we're going to be filing what types of pleadings on there. What I will tell you is that I probably get about 100 emails a day from the lawyers back and forth, reviewing documents, reviewing pleadings, and there is a frenzy of activity that's happening behind the scenes on that case. I said last week that we are very, 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 very close to having something where I can talk to you about it. It will probably, it's going to be very soon. And I will, I'm going to obviously know I know exactly when everything that we're working on is actually going to be filed and all that. But I'm not telling here anything about dates or what we're filing, or well, I guess if we're filing, but I'm pretty sure that everybody knows that we're not going to basically just sort of sit back and wait. But what I will tell you is that when it's, as soon as it drops, I will be watching with all the other lawyers and seeing when it ends up officially accepted by the courts. I will do a live stream for all of you talking about specifically what just happened. So that's going to be, like I said, soon on there. I've already seen what's going on, and I know that it's almost ready. Okay, let's move on. We had another question on the gold card. Who is the gold card for? It will be subject to numerical caps, and those who aren't caught in the caps can file. So he'll basically, I think what they're saying is that they're just going to steal numbers from the EB1 and EB2 categories for the gold card. It doesn't have its own cap or its own numbers because Congress never actually authorized this. So all they're doing is like quite cleverly saying, oh, you have $1 million that you've given to the U.S. government. You obviously are a very extraordinary person. Thank you very much. You can file for an EB1, and we will consider that to be all the evidence we need to show you're extraordinary. Or, oh, you gave $1 million, $2 million company to company X to the Treasury. Obviously, that means you're doing, you've done something that provides a national benefit to the country. So your people get national interest waivers. I mean, that's basically what they're saying. They're just basically saying these existing categories, EB1 and EB2, they're going to allow people into those categories to squeeze out more numbers from people that are legitimately supposed to be in these categories. That's why they're going to get sued on this, because it's not authorized by Congress. And also, there are going to be plenty of people who are going to be furious that they actually meet the requirements that Congress set for these categories and are being passed in the line by these people who are basically paying bribes to the administration. So that is that's the again, but I think if you file in the EB2 category, EB1 category under this, you're basically going to end up, these applications are going to get denied. You may or you may not get your money back. And then at the end of the day, you're going to have a later priority date than you would have if you filed in a legitimate category. So maybe if you have an I-140 already filed and you have a priority date from before that, you're not going to screw around with that. But if you are like basically filing initial applications in EB1 or EB2 based on the gold card, and you're saying, well, I'm not going to start an EB5 application unless I get denied those, and you're in a category like from India or China that's backlogged in EB5, you basically have screwed yourself because you have lost time that you could have had in that category. So I would be believe me, it's like, I would love to, if Congress wants to pass this stuff and create new numbers I would love to have clients filing for these things. I don't want to have clients basically turn around and say to me, why did you let me do this on here? You knew it was illegal. You knew it was probably going to go to court. You knew that it was, and all that. So any lawyers who are watching, I know there are a lot of lawyers who are watching, you need to be really, really careful. I'm saying right now here tonight that if you are a lawyer and you are advising clients to file cases in this category, you should be prepared for the consequences when those clients turn around and file bar complaints against you for filing cases that you knew were very likely going to get denied, and people were going to potentially lose a ton of money, and they also were going to lose time in the lines when they could have been filing in other categories. That's my warning for lawyers right now who are getting excited about saying, hey, I've got rich clients, I can get them to file these things. Find other categories that are out there. EB5 is, that's what Sahil said, that's potentially a good one. Okay. So we got somebody who's got a 2015 priority date in EB2. Why do I think you'll be getting do I think you'll be getting your green card in the next 5 years or not? I actually am somewhat optimistic in a negative way about dates moving more quickly. And I think that's because I think we're just going to be seeing a lot fewer people that are excited about applying and filing for green cards in the United States. I also think we're probably so you're 10 years out. My guess is that, as the dates have been getting longer and longer, I mean, I've heard anecdotally, especially like when people's kids are getting close to turning 21, or other countries are now trying to recruit, like Canada has a new program since this $100,000 thing came out to try and attract H-1Bs to go there. I don't think the demand for employment-based green cards is going to be going up in the next few years. I think that we're going to see soft demand because of the administration changes, as well as I think the economy is is going to be going through some hard times. If I had to guess, in the United States over the next couple of years, when that happens, a lot of times people exit the country that were in line, and they've just decided that where they get laid off, and then there's a lot of things that happen, but basically, when things are going great, that's when the backlogs are more, get worse and worse. It's when things get soft, that's when actually demand tends to lighten. But otherwise, it's just looking into a crystal ball and trying to predict, and I don't think that I'm very good at predicting, so I'm not going to try to get more specific than that. Marshall, I don't know what you think, but I have seen some scary numbers from National Foundation for American Policy on how long green card waits will be in EB2 and EB3, and they're very scary. But sometimes the numbers shift around when things are going on. So, Marshall, I know that's a topic that a lot of lawyers are talking about whether it's advanced parole or any kind of paroles are safe. I think for right now, we're not hearing about any specific problems with respect to pending adjustment applications. What I will say is that with respect to adjustments, it seems like the thing that is really scary right now are people who are not maintaining underlying non-immigrant status, or who are filing and have had status violations before they file. In the past, we used to tell people that, I've always told people pretty much through my whole career, it's like a good idea to keep an underlying non-immigrant status just in case something happens to your green card application. But which was, just practical advice, because that green card application can be denied any time. And then if it is, then you have at least you have an underlying status you immediately revert back to. But now you need it because they're not even necessarily honoring the fact that you are maintaining status because you have an advanced parole application pending. So it's like another good reason to keep that underlying non-immigrant status pending. But if let's say you have an H-1B, or you have some, an H-4, and then you have if you have the advanced parole, I believe if you come back in, this is where I'm glad I always have another lawyer pair with me, because it's actually doing this every day. But if you enter on advanced parole or pending a I-485, and you have you have an H-1B, you're still in H-1B status once you re-enter the country. Is that correct?
Yeah.
So I think the answer to the question, on it is, I think is a general rule. If you're coming back in on with a pending adjustment application on advanced parole, I haven't heard specifically about. All I've heard about are about people that are being denied adjustments and then put into and given notices to appear because they didn't have an underlying non-immigrant status. That seems to be just anecdotal, and it doesn't seem to be in a lot of that it's across the board. So I would say that, if you're maintaining an underlying non-immigrant status, I don't have any problem using advanced parole for travel. I think you have to, I'm trying to remember the old rule on it as far as the advanced parole, where you have to, if you have an H-1B, you could come back in on the H-1B and the adjustment continues to be pending even if you don't have advanced parole, I believe is the rule. Is that correct? I think I might have to do some double checking on the rules on that. So see, my general warning, yeah, my warning is, I don't think advanced parole is being treated like the other parole categories as far as, that they are kind of revoking it. They're treating advanced parole for adjustment a little bit differently. But where I think the risks are, it's not on the advanced parole and whether that's going to be honored or not for 45s, but whether they consider you to be, whether they consider the whole adjustment application to be deniable or not if you are not maintaining an underlying status. So if you want to send me a note for if that wasn't clear, I'm happy to address that offline. And then we had Misha saying thank you. So I think that was the questions for tonight. It is almost top of the hour. And Marshall, I wish your Tulane Green Wave all the best of luck in the college football playoffs. The Vanderbilt is going to a bowl that is the ReliaQuest Bowl in Tampa, Florida. That's where I went. And our consolation is that we have it is in a warm weather location, whereas I think the Tulane Green Wave is going to have to play its first game on the road in some probably very cold place, and they're probably going to get demolished. Sorry, Marshall.
Yeah.
So Vanderbilt will be in warm Tampa, probably winning, and maybe Diego Pavia will get the Heisman Trophy. I think he's the best quarterback in the country. We will see. So more to report on that next time. Thanks everybody for watching, and we will be back next Wednesday night. And I am sure that there will be many efforts to ruin people's Christmas and New Year's holidays with exciting new immigration policies that we will be reporting on. So wish you all well, and thank you for watching. We'll see you next time.
Good night.